Hi, everyone. We are starting with the webinar. We just let a couple of minutes for all people to join, and then we will officially start. So, good afternoon, everyone. Very welcome to this webinar, where we will discuss with a terrific set of panelists some of the major recent developments in terms of corporate accountability, and we'll try to look ahead to possible future consequences of this development. My name is Maddalena Neglia, and I am the responsible of the Globalization and Human Rights Desk Office at FIDH, the International Federation for Human Rights. Before we start, just a couple of technical details. The event is recorded, so please keep this in mind. You can see on the slide, on the next slide now, that the agenda of the event. We will have 3 panels, like as you can see. So a panel from that will talk about climate litigation, another one that will talk about civil liability, and a third one that will talk about criminal liability. And we will have a space for closing remarks and next steps. After each panel, there will be a short time for Q&A from the audience. So you will be able to ask your questions through the Q&A feature that you have in the toolbar down to your screen. We will select a few questions for each panel, and those will be answered live. This event is interpreted in Spanish and French, and you can access interpretation by clicking on the button interpretation in the toolbar, on the right part of the toolbar down of your page. So after these technical details, let me just say that I'm very honored and glad to officially launch today the latest update and the brand new format of the FIDH Corporate Accountability for Human Rights Abuses Guide. From now on, you can consult the guide by using this website that you can see on the slide. And the version that we launched today does not only contain some of the more recent developments in the field, but also it's published in a very new online format with the objective to make it more widely known, accessible, and more easily readable. So many of you might know that in 2010, FIDH published for the first time its guide on corporate accountability for human rights abuses, under the impulse of its, at the time, Secretary General, Professor Olivier de Schutter, who is with us today. And the objective was to provide a practical tool for victims and their representatives, NGOs, and other civil society groups, lawyers, to seek justice and obtain reparation for human rights abuses involving multinational corporations. To do so, the guide explores the different judicial and non-judicial recourse mechanisms available. As it is illustrated through the different sections of the guide, and you will see if you go on the website, the range of mechanisms that are available to try to obtain redress for corporate-related abuses is diverse, from invoking states' responsibilities before the international human rights protection system and corporations' liability before domestic courts, to initiating mediation processes with ombudsmen or OECD national contact points instances. Recourse mechanisms may take various forms and result in different types of outcomes. And in particular, this year, in 2021 and later 2020, we have seen a lot of exciting developments with respect to access to justice for victims of corporate abuses, for example, in the domain of civil liability of parent companies or in a climate litigation. And we will discuss more in depth about these developments in a minute. And unfortunately, we also have seen some less exciting developments also coming. So, for example, you might have all seen yesterday's very fresh Supreme Court decision on the ATS in the case Nestlé. So this reminds us that despite some positive steps we have witnessed recently, the real question is still there. Can all these mechanisms effectively bring justice to victims? Do they fulfill victim rights to an effective remedy? Do they offer adequate sanction to change corporate behavior and help deter future violations? We have been fighting for decades alongside civil society groups and local communities for accountability and redress in the context of corporate-related violations. And this guide, although highlighting potential avenues, also reminds us that to date, none of the existing mechanisms can truly live up to the meaning of an effective remedy. So we all have to continue working to make access to justice a reality for victims of corporate abuses. Our hope is that this guide is one of the instruments that could constitute a useful tool for all those who are working in this area. So for this reason, we are very proud to be able to share this tool with you. And I am glad to give now the floor to Professor Olivier de Schutter, who has not only impulsed the beginning of this work 11 years ago, but who has continued to support it through the years. And for this, I cannot really thank him enough. So Professor de Schutter, the floor is yours.
Well, many thanks indeed, Madalena, for these very generous words of introduction. And let me thank especially the International Federation for Human Rights, la Fédération Internationale des Ligues des Droits de l'Homme, for its fantastic work on this issue through you, leading the Globalization and Human Rights Bureau, but also Sasha Feyerabend, who's been so instrumental in updating this guide. When this was initially developed, this guide, the intention was to show the practical avenues that victims have to hold corporations accountable. And the message was back then, as the future guiding principles on business and human rights were being discussed, that accountability and effective remedies mattered, and that we could not content ourselves with soft law mechanisms and the tools of corporate social responsibility. I know that the guide has been very widely used for comparative law purposes, for equipping NGOs and victims of human rights abuses by companies, and I'm delighted that it has now been significantly improved with the updates introduced and the new presentation of the website. Now, 11 years ago, there was not even a section on climate change and accountability of corporations. However, the litigation around climate change has been growing very significantly over the past 20, 30 years, and it has become impossible to ignore. Since 1990, according to a recent count, there were 1,500 cases in 37 countries concerning climate change, litigating against states or against companies. And this is an exponential growth we are witnessing. The number of cases concerning climate doubled between 2017 and 2020. So it is a very fast growing area of litigation. Increasingly in recent years, litigation referring to climate change uses human rights. There were only 5 cases in 2015 that invoked human rights to challenge states and corporations to do more to mitigate climate change. There were 40 cases introduced between 2015 and 2020. States such as the Netherlands, in the case of Urgenda, such as France, under l'affaire du siècle, before the Administrative Tribunal of Paris. Just yesterday, in Belgium, the Belgian state was told it was liable for not doing enough to mitigate climate change. So many of these cases are filed against states. But we also have, of course, and this is why we are here today, cases against corporations. The most recent and spectacular example is the case filed by Greenpeace and Friends of the Earth, Milieu Defensie, against Royal Dutch Shell, a company incorporated in the Netherlands. On 26th of May of this year, just less than a month ago, the Hague District Court imposed on Shell that it reduce its emissions responsible for climate change by 45% by 2030 in comparison to the year 2019. And in its judgment of 26th of May, the District Court of The Hague referred to the OECD guidelines for multinational enterprises and to the United Nations guiding principles on business and human rights as providing an unwritten standard of care that those companies should comply with. So we see how those soft law tools can be supported by human rights arguments in order to ensure that companies contribute their own fair share to climate change mitigation. And indeed, this is especially important if we recall that a significant part of greenhouse gas emissions can be attributed to a relatively small number of economic actors. One count is that the carbon majors, the 100 most important companies in the world, are responsible for 70% of total greenhouse gas emissions in the world. So targeting companies makes sense. It's one way to ensure that governments move forward, because governments may be hesitant to impose burdens on their companies under their jurisdiction. And so if courts do not step in, companies may be left to pollute without governments taking their responsibilities. So it is in this context that we organize this panel. And I am glad to give the floor first to Annalisa Savaresi from the University of Stirling. She will be speaking about litigation against companies for failing to do enough to mitigate climate change in a general and comparative law sense. And then we'll turn to Hasmina Podak to speak about the experience of the Philippines. Annalisa, the floor is yours.
Thank you very much, Olivier. Indeed, thank you very much, Madalena, and the organizers for inviting me today. There is so much to say. There is so much litigation happening presently, as Olivier just mentioned. But I would like to focus our attention on two key developments in climate litigation against corporations in recent years. The first, and Hasmina is going to talk more about this, was the carbon mayors inquiry carried out by the Philippines Human Rights Commission. This inquiry marked a milestone for many reasons, but I would say, first and foremost, it demonstrated that national human rights bodies can and should look at the responsibilities of corporate actors for climate harms. And this is especially so when these are not headquartered in the territory of a state where the investigation takes place. Then the Shell case that Olivier just mentioned marked another important milestone, because here, tort law at the national level has been construed in light of obligations enshrined in human rights treaties like the European Convention of Human Rights and the International Covenant on Civic and Political Rights. And as Olivier mentioned, the Dutch courts were particularly proactive in relying on what may be regarded as soft law standards and turned them, at least as part of a European legal system, into actually norms that could be used to interpret human rights related duties of states and corporate actors. Now, here, it's very important that we try and understand what the role of human rights law is in this context. As I've written on many occasions by now, there is a clear accountability gap, both in the international and in national law, that is being progressively filled by making recourse to human rights law and arguments and remedies. So in this connection, litigants around the world are increasingly using, as Olivier has explained, human rights to ask courts to order states and corporate actors to reduce emissions on the one hand, but also to prevent and redress harm associated with the impacts of climate change. There has been less of the latter kind of litigation, but we are going to see more and more of it. I've recently written a paper with my friend and colleague Joanna Setzer, where we map this litigation, and the numbers, as Olivier said, are striking and rising constantly. We must always remember that what the end game is. The end game is, of course, not to win court cases, but to change behavior. And here we're talking especially about corporate behavior. I believe that in this connection, the Shell judgment has marked a milestone that shows how courts may fill in a major gap in corporate governance using the tools that already exist. And thus prompting lawmakers that are looking at this issue both at the international and at the European level to do more, to equip them with better tools to systematically deal with corporate behaviors that are not acceptable in the climate emergency in which we find ourselves today. And in this connection, the countries that have due diligence legislation are clearly in a better position. Notre affaire à tout and others, and brought a case in France against Total, exactly relying on French due diligence legislation. We have, however, to remember that this is going both ways, and that sometimes climate change response measures and projects may also affect the enjoyment of human rights. I'm sure that you've all heard of indigenous peoples and civil society organizations relying on the same French legislation to ask the energy company EDF to suspend the building of a wind farm that violated rights of indigenous peoples in Mexico. So we have to keep the whole picture in mind and remind ourselves of the centrality of human rights in climate action, both when it is to prompt mitigation, but also when it's about making sure that the transition to a net zero world is a fair and just one and is aligned with the respect and protection of human rights. And I think I'll leave it to that because Hasmina has many more things to tell you about the Carbon Mayors Inquiry. I'm sure you want to hear what she has to say about their experience in that.
Thank you, Annalisa. Very gracious of you. We certainly will revert to you because there will be a session of questions and answers, and many of the things you said deserve certainly unpacking. Let us turn now indeed to Hasmina Bodak from the Climate Justice and Liability campaign of Greenpeace to discuss this important and inspiring example of the work of the Filipino Commission on Human Rights on the extractive industry, the Carbon Majors Inquiry. Hasmina, the floor is yours. Thank you.
Thank you, Olivier and Annalisa, for already laying the ground or foundation for my presentation tonight. A pleasant morning, afternoon, and evening to everyone for my intervention. I will be speaking through the practical lens as mentioned by Olivier, primarily sharing with you the lessons we've learned from our almost 6 years, that's correct, 6 years journey to hold carbon majors accountable for climate-related harms in the Philippines in light of the current developments in climate corporate accountability. Although this legal action was filed earlier than the Milieu Defensi case against Shell, the historic judgment in the Milieu Defensi case is a welcome development as it really bolstered our theory on using or incorporating human rights angle in climate cases, which was in its infancy back then when we filed our petition in 2015. For those who aren't really familiar with our legal action, briefly, it was a petition filed before the Commission on Human Rights of the Philippines by 32 petitioners against 47 carbon majors like Shell, ExxonMobil, Chevron, BP, and Total. They're requesting for an investigation of the responsibility of the carbon majors for human rights violations or threats thereof resulting from the impacts of climate change. While we haven't actually received the Commission's final report, by the way, we just filed last Friday an ex parte manifestation and motion for urgent resolution of our petition, we've already gained substantial preliminary wins, specifically when the Commission confirmed the clear role carbon majors have played in anthropogenic climate change and its attendant impacts, and highlighted the corporation's obligations as business enterprises to do their part in mitigating climate change, including the responsibility to conduct climate change and human rights impacts assessments. Also, the Commission responded to some of our pleas, particularly when it already launched the Climate Change Observatory last September 2020, mandating monitoring of human rights violations in the context of climate change and creating a repository of evidence that will be a very useful resource for the public in building their climate case or even launching a new ones. Since I was given just limited time to present, I will just share some significant takeaways or lessons we've learned from our climate justice journey that could perhaps help shape the current and future endeavors on corporate accountability. Can you see my slide? So
we can, thank you.
First lesson here is defining the precise obligations of the carbon majors under due diligence law. In the absence of an international treaty on business and human rights at the moment, using, as mentioned by Annalisa earlier, using human rights law in particular, human rights due diligence enables plaintiff to articulate the specific obligations of defendants. The argument we made was that respondents are acting unlawfully under the UN guiding principles as informed by international law and domestic law. And we also argued that the respondent carbon majors have a legal responsibility to respect, including through proactive measures, the human rights of the Filipino people. We argued further that complying with their human rights due diligence entails that the carbon majors must produce, in consultation with relevant stakeholders, a robust analysis of the company's direct and indirect greenhouse gas emissions and describe how they will reduce emissions from their operations and products in line with the global carbon budget implied by 1.5 degrees Celsius temperature goal at a minimum in order to avoid infringing on human rights. Here, what is important to remember is that the due diligence in the climate context should never be only about the process, but about the outcome of limiting warming to below 1.5 degrees Celsius and providing justice to communities. Now, while the UNGPs are seen as soft laws mentioned by Olivier earlier, we argue that they are instructive in defining the specific obligations of the respondent carbon majors because they restate and codify existing international and national legal standards in human rights and business enterprises. This was affirmed by the Milieu Defensive case, particularly when the court held that the international human rights and other soft law instruments are properly applied to carbon majors when evaluating the obligations with regard to climate change. The court took guidance from a variety of international frameworks, including the UNGP and the International Covenant on Civil and Political Rights, noting that the UNGP constitute an authoritative and internationally endorsed soft law instrument which set out the responsibilities of states and businesses in relation to human rights. Now, here, the court emphasized, which is very useful, I think, for current and future climate cases, the affirmative and individual responsibilities of carbon majors, independent of governments and other parties in society, explaining that their obligations apply both to actions and omissions, and that respecting human rights is not an optional responsibility for companies. It applies everywhere, regardless of the legal context, and is not passive. Now, the second lesson I want to point out is triangulating evidence and strategy to increase impact. While establishing climate science is imperative, triangulation of evidence is significant to sustain the process and prove your case. This means presenting three main pillars, in our case, community witnesses who are experts of their own stories, national experts and international experts in the field of climate science, law, policy, and research. Now, the triangulation in strategy means treating your case not just as a legal action, but actually complementing it with community or grassroots work, political work, and storytelling and campaigning. Community work is important to change mindsets and behavior. Political work supplements the legal case because there will always be limitations on the power of the commission or the court hearing a particular case, and storytelling and campaigning are powerful tools to elevate the discourse and change the narrative, which is very important. And finally, continuing the efforts to achieve substantial global impact, the national inquiry marks only the beginning of the community-led efforts to hold fossil fuel companies accountable for human rights harms. It is now up to everyone listening to carry the efforts forward based on today's circumstances. To underscore, cases can be brought forward against private actors not only on the basis of loss or damage or financial liability to create systemic changes through possible national law or policy changes. One route to go, which is gaining traction, as mentioned by Annalisa, is a human rights angle. As mentioned earlier by Olivier, yesterday, the courts of first instance of Brussels has collectively condemned the Belgian authorities for their negligent climate policy, and the judges there ruled that the Belgian climate policy is substandard and not only violates the legal duty of care, but also human rights. Again, the human rights angle. Particularly as mentioned, the milieu defensive case, it further cemented our argument or strategy on using the human rights lens in the context of climate change. It puts to rest the question of whether carbon majors have legal responsibilities with regard to climate crisis. Climate polluting companies, their subsidiaries, and other entities in the supply chain have obligations independently of the state to prevent and redress human rights harms in the context of climate change. And now fossil fuel producers can no longer shift the responsibility to consumers. And also for fossil fuel companies, they are now more vulnerable to accountability efforts. Our legal action, together with the milieu defensive case and other related climate cases, has opened up the space for communities, lawyers, and scholars to consider how human rights law should respond to fossil fuel companies' anti-net zero commitments and misleading green advertising. Also, they can possibly be used as a yardstick on the responsibilities of the fossil fuel industry and ultimately build the power of communities to take legal action to protect their rights to a safe and a healthy environment. I think on one last point, if I may, the district court's ruling also, reasoning on the standard of care in the milieu defensive case informed by international human rights law could potentially also be used to hold other types of polluters to account, from perhaps industrial agriculture to industrial fishing. It could also have implications for the financial backers of corporate polluters who are bound by the same obligations under the international human rights law, the UN guiding principles on business and human rights that inform the Dutch civil law provision. So I think I will stop from there, and would love to hear your thoughts during the Q&A.
Fantastic. Many thanks indeed, Hasmina. Many thanks, Annalisa, for your presentation. I would perhaps like to note that it's ironic that in the milieu defensive case that both of you referred to, decided on 26th of May by the District Court of The Hague in the Netherlands concerning Royal Dutch Shell, reference was made to the UN guiding principles on business and human rights, as well as to the OECD guidelines for multinational enterprises, in order to impose on Shell obligations directly derived from international human rights law, despite the fact that international human rights law, as we all know, is primarily directed to states, and that when the UN guiding principles were adopted, the whole idea of saying that companies had a responsibility, not a duty, to respect human rights was because of the conviction of John Ruggie that it was not possible to impose direct human rights obligations under international law on private actors. So quite ironically, now these tools are a channel by which human rights obligations are being imposed directly on them. So perhaps three questions. Two of them addressed, one of them addressed to both of you and one to each of you. First question is whether, Annalisa, you could say a few more words about the lessons from the ADF case in Mexico and the deployment of wind farm in Mexico, and how to balance the rights of local communities against the need to make an energy transition. I think it would be very useful to discuss the case in the light of that question. Secondly, this is a question to Hasmina, whether in the Filipino Human Rights Commission deliberations, use was made of national constitutional rights. I mean, constitutional rights as described in the National Constitution of the Philippines. And then to both of you, how would you address the question of the coexistence of human rights law on the one hand and investment law on the other hand, that protects the rights of investors, foreign investors, for example, under the Energy Charter Treaty that was adopted in 1994, entered into force in 1998, and protects investors in the energy sector from any form of expropriation, direct or indirect. Might it be said that imposing on companies in the extractive industry or in oil and gas sectors, for example, that they contribute to reducing greenhouse gas emissions, may lead these companies to sue the states imposing such obligations, alleging that this amounts to a form of indirect expropriation that requires compensation from the state concerned. So these are three questions. Maybe we can start with you, Annalisa.
Thank you very much. Very good questions. It would take a while to answer them in full, but I'll try my best. I will probably start with the last very quickly and say that investment law has long been a thorn in the side of environmental lawyers. But what I would say about the Energy Charter Treaty is that it's not forever. The Energy Charter Treaty is being abandoned by an increasingly large number of states because of the perverse outcomes that it has achieved in certain contexts. So we have to wait and see what happens there. But I really think that we may be looking at a treaty that has served its purpose and maybe set aside or adjusted in light of the challenges that we are faced with. Which brings me to the question of EDF. I mentioned already the work I've recently done with my colleague, Joanna Setzer. Joanna Setzer is the guru of climate litigation working at the Grantham Institute at the LSE. And what we discussed for a number of years and finally put on paper is that we have the prominent climate cases that we are talking about, Milieu Defensi, the Cabo Meso inquiry, Urgenda, but we also have the dark side of the moon that we don't know very much about. And the EDF case is a very good example of how many of these cases there are out there, but they are like the everyday cases. And these are about communities, groups, individuals that are harmed by climate change response measures. And their voices must be heard because we need to transition, and the transition is urgent, but it must not happen at any cost. And greater attention should be paid to this mountain of cases. We have a strong feeling that there is way more of these cases than the other very sexy, prominent climate cases we have been discussing so much. But somehow the voices of these people are going unheard, and abuses are being committed. And this is not good practice, shouldn't happen. And we have to learn from these cases. And there is much more that needs to be done from the human rights cohort to understand how to do a transition that is fair and just for everyone. Now, tort law. There is a lot that can be said about the role of tort law. A lot of literature has been written already about how tort law could be ameliorated to better cater for climate harms. So I will not say a lot about this other than there are specificities in the way in which tort law works in different countries. And the Netherlands has been a particularly convenient forum to bring this kind of litigation exactly because of the way its tort law works. Having said that, replica cases are being brought elsewhere, most recently even in Italy. We have to wait and see how progressive the judges in these various other countries are willing to be. And it's a long game, but I do think that we have to see this litigation in perspective. This is all about convincing the lawmakers that there is a gap for them to fill. We've seen this in the past in relation to environmental liability. It may take a while, but eventually the lawmakers move. In this case, we want them to move a little bit faster. So hopefully the floodgate of litigation is helping.
Many thanks, Annalisa, indeed, for reminding us of this dark side of the transition, which may affect the rights of communities. And the EDF case is a good illustration of this. Hasmina, back to you.
Yes, Olivier and Annalisa, thank you for that. I will answer the question in the constitutional, if I got it right, the constitutional aspect. When we filed the case, actually, that is one of our one of our bases, the constitutional right to life. We actually mentioned different rights included here. The constitutional right to life, to the highest attainable standard of physical and mental health, to food, water, to sanitation, adequate housing, to self-determination, particularly likely to be affected by climate change, including the women, children, persons with disabilities, and those living in extreme poverty, indigenous peoples, displaced persons, and also as well as the right of Filipinos to development, those Filipinos abroad and working abroad. So I think on the constitutional aspect, actually, when we filed our case in the Philippines, we had to hurdle the jurisdictional ground. And in hurdling that jurisdictional contention by the respondents, we heavily relied on the constitutional provision on jurisdiction of the Commission to investigate all forms of human rights abuses, wherever these may be taken, wherever these may take place. And these rights that I mentioned earlier is encompassing. Particularly, we are not just saying the right to life already embraces also the environmental, social, cultural, and EC, or basically the ECSR rights. So did I answer the question on that aspect?
I'm sure you did. This was a question that came from the audience, and I would recommend that they turn to the information that's available around this inquiry that hopefully we can place in the conversation box. Let me turn now to Maddalena Nelia to see whether she has other questions to propose.
Thanks, Olivier. There is a request more than a question to clarify where soft law was interpreted as instructive in the case, for example, of which Hasmina has talked about, in interpretation of human rights obligation, but you already, Olivier, addressed that in your remark. Right. Otherwise, I have another question on the Shell case and what Annalisa mentioned about changing behavior. So it's directed to both. So do you see that this type of cases is changing behavior in the end on corporate actors? And should we expect a backlash from the corporate sector after this type of cases? What's your opinion?
So is this question addressed to Annalisa, to Hasmina, or to both?
To whoever, to both. I think they both.
So the first reply. One to open her microphone will take the floor. We have just a few minutes left. Annalisa.
Thank you. I would definitely expect a backlash. There is always a backlash in the face of litigation of this kind. At the same time, things have changed dramatically in the last few years. Only when the Paris Agreement was adopted in 2015, we could see very high level proclamations that were followed by very little actions by the corporate actors. But now the game is changing, because once you start hitting these actors in the purse and really force them to change the behavior, then they will change or go out of business. One of the two. It's sad but true that these businesses really need to radically change their model if they want to survive. So the ones that do will survive, the ones that don't will perish. And this is brutal, but this is what we need to see happen.
Thank you. And I'd like to second this by noting that it's a huge financial risk for companies to ignore the impacts on climate change of their activities. There was one press release from the United Nations Framework Convention on Climate Change Secretariat that estimates that major companies face $1 trillion in climate risks if they ignore the impacts on climate of their activities. And that is because if they do nothing, they will be late when responding to regulation. They will have huge stranded assets that they will have invested in without being able to exploit them. And so the message is, the sooner they change their business models to adapt to a low carbon type of economy, the best equipped they will be to accompany this transition and to be, in fact, leading rather than being coerced into making that change happen. And I'm going to put in the chat box the link to that document, because it's a very strong encouragement for companies to take seriously their role in climate change mitigation, as this is good business. And I think it's important, therefore, to show that companies expose themselves to huge financial risks if they remain passive. Nina, do you want to comment on this?
Yes, if I may also add, while different jurisdictions mean different legal avenues to actually pursue, but plaintiffs around the world can and will use the underlying principles that fossil fuel producers have obligations to reduce emissions in line with the science, and Shell and other fossil fuels now are on notice that if they continue to produce, they could be sued. So I think that is an important message to put across. Over.
Great, many thanks indeed, Hasmina, for those concluding comments. We now shall close this first part of the webinar, presenting the new FIDH guide on the accountability of corporations, which discussed the question of climate litigation. The next topic will be civil liability, and Maddalena Nelia shall share this, shall chair this second part of the discussion. I would like to thank the co-panelists, Hasmina Podak and Annalisa Savaresi, for their excellent comments, and I look forward to our continued conversation around these important issues. Thank you.
Thank you very much, Olivier, and thank you, Annalisa and Hasmina, as well from my side. So yeah, I know, Olivier, that you might have to go, but thank you again very much for everything and for your presence here. And we'll now switch to another area that has seen major developments this year, particularly after decades of litigation, and which is the civil liability of parent companies for human rights violations in their supply chain. So we know that in countries where the parent companies of multinational corporations are based, a variety of systems have been tried over time to prosecute multinational companies for their abuses, despite the complexities of their structures and operations. And this is, of course, a very important avenue, because the individuals affected by multinationals' activities often have a low probability of obtaining redress in their own country, the host country of an investment. So this topic is at the very heart of the business and human rights debate since its beginning, and is the area where the gaps in the normative system become the more evident and have given rise to a sort of impunity for multinational corporations for the violations they commit along the supply chain, given the very heavy obstacles that victims face and have faced to obtain redress for this type of abuses. Despite those difficulties, many lawyers and civil society organizations have tried for years to use available civil liability national mechanisms to hold companies accountable. And some of those cases have led to some preliminary decisions this year that open the door for future positive developments. Furthermore, we have seen the adoption of the French legislation on duty of vigilance in 2017, and the cases that followed that, which were mentioned also earlier by Annalisa and Hasmina, have yet again shown the importance of strong provisions on liability contained in new regulatory instruments. And the debate that is following this now in Europe and in other countries around mandatory human rights due diligence legislation, for example, opens a window of opportunity to reinforce these legislative provisions on liability, and particularly on civil liability. But we can already see, and we have seen particularly, maybe Miriam will touch on that, after the adoption of the German due diligence legislation last week, that this won't be easy to achieve. It's not a won battle. So I turn now to our two next panelists for this round. Miriam Saremas, who is Vice Legal Director and Program Director on Business and Human Rights at ECCHR, and Dr. Lucas Roorda, lecturer at the University of Utrecht. So they will help us to shed some light on this topic, and I ask you both to give us your perspective on what are the key developments of this recent months of this year in civil liability and duty of care cases, and also what could be the lessons from those developments concerning the broader reflection on corporate accountability, and particularly in light of the current discussion on mandatory due diligence legislation. I'll give the floor to Miriam first and then to Lucas. And I just remind you and myself as well to talk slowly because we have interpretation.
Thank you very much. Thank you for the invitation, and also for organizing this very timely panel on corporate accountability. And I do think, yeah, it's always good to take some time after a while and to look back and to evaluate, you know, where have we been, and so what has been achieved. And indeed, it's been quite remarkable, the developments of exactly this year, I would say, in terms of when we look at the question of civil liability of corporations for human rights violations, either that are caused or contributed to by their subsidiaries, but also with regards to their supply chain. And as been highlighted in the panel before us, that it's quite remarkable how courts have been picking up the UN guiding principles in the interpretation of existing legal duties of care or companies' obligations. I think I'm very pleased to see this, because this is really what we at ECCHR have been seeing ever since have been seeing as a very strategic goal that we all as civil society should be aiming for, that courts do acknowledge soft law norms as guiding their thinking and interpretation of legal obligations of companies. So this is a very, I think, and also a development that could not be underemphasized. So I think also, again, if we look back, for example, let's say 10 years ago, I think most of the litigation, comparatively successful litigation had been happening back then in the United States under the Alien Tort Claims Act. And I think since then we can see that there's really been a shift. While the Alien Tort Claims Act has been cut back in its scope of application and so forth quite dramatically by the Supreme Court in the US, we have now just recently seen the Supreme Court of the United Kingdom coming down with the Vedanta decision in 2019, I think, end of 2019, and the Okbabi case just a few months ago. And I think those two decisions really are very crucial, because they're widening the categories of duties of care of companies with regards to their subsidiaries, and therefore give much more opportunity, in my opinion, to persons that have suffered harm by corporate actions and whose human rights have been violated to actually claim damages from companies. And the way the Supreme Court has done this is that they have taken away the criteria that had been set forth beforehand in, for example, Caparo v. Dickman or in the Chandler case. And they are now under standing control, which then out of control comes the duty of care, or derives duty of care. They see it as a fluid concept, and especially which is influenced by internal companies' policies, but also by external policies. And I think that is a very important step, because it actually finally also means that what company claim to do with regards to their subsidiaries, or what they claim to do in terms of human rights, environmental impacts with regards to their supply chain, actually now becomes legally binding. Also something that I think we as civil society organizations all have been demanding for the last at least the last decade. And then another important decision, which is I think is not at the Supreme Court level, but at the High Court level, is Bengun versus Marin, where exactly that concept has now been transferred onto a supply chain relationship. And interestingly, also there, I think you know, those decisions, in my opinion, are not only bear a chance for further litigation in the UK, but also given that under normal conflict of law regulations in Europe, it's always the foreign law that will be applicable in trans-border tort cases. So in cases where victims want to claim damages from a company that is located in Europe. And under the Rome II regulation, it will always be the law that is applicable in the country where the harm has occurred. So, and that means that I think in all countries of the Global South that have a common law jurisdiction, it will be possible to argue that in case of absence of relevant court jurisprudence in the country itself, courts will look at the UK jurisprudence and also seek guidance there in terms of on how they're going to interpret the duties of care. So I think this jurisprudence will and should be really used by organizations and lawyers in continental Europe in cases that are common law countries, meaning that were our former British colonies. So, and I think why I also believe this is exactly how we have been arguing the case that we have brought against the German textile retailer KIK with regards to a claim of surviving surviving workers of a factory fire in Pakistan. It's a supply chain case, and we did exactly. We took the UK jurisprudence at that time and said, you know, this needs to be applied because in the absence of relevant Pakistani and also Indian jurisprudence, we need to look to the UK jurisprudence. So I think quite separate, and to some extent, I would say quite separately, but now I guess there will be more like this dynamic coming from the UK, but also from the Netherlands, of course. We had the successful Shell judgment with regards to oil spills, and now also being finally decided in the Netherlands. So I think with those UK and Shell and the Dutch developments, I think in general, this will be informing the debate on mandatory human rights diligence that is going on both at the national level and the international level. And there, if you look at this, I think what I would want to focus on is what I call comprehensive human rights due diligence laws, which are laws that also actually not only bring reporting obligations, but also actually have a remedy attached. That's first and foremost, it's the French loi de diligence, but also now the German law is also, as it is providing not a civil remedy as the French law, but an administrative legal cause of action, where also persons negatively affected by company behavior can actually go to German administrative courts and demand of the government agency to properly investigate into their grievance, but also provide for sufficient remedy. I have one more minute, probably, Madalena?
Just one.
One, yes. So, and I think what we can see here, and what I think will be the future struggles, as we can see all those human rights obligations under those new laws have some shortcomings. You know, they can be limited in scope in terms of applicable to which company size. They can be, as in the German case, very limited in terms of the risk assessment that needs to be taken, which is very close. That's actually only about very concrete risks or harm, even though having have to occur. But still, I think those laws need to then be used in practice and brought before courts, as it's now being done with a French case, you know, to be really that we really make sure that the obligations in those laws are interpreted really in line with the UN guiding principles. And I think that must be while we may criticize them, but we really must use them in practice. And again, use courts and you know, court procedures to really work hard and fight hard for the right interpretation of these norms. Thank you.
Thank you very much, Miriam. I will now switch immediately to Lucas, and then we'll have the question moment.
Thank you, Madalena, and thank you for inviting me on this very distinguished panel and a great session altogether. And also congratulations on publishing this new guide, which is, from what I've seen, very, very comprehensive, and I think very necessary also to push this litigation forward and give some understandable avenues for those wishing to enter sort of this debate. So that's, I think, already a very relevant contribution. I'm going to sort of identify, I think, some of the barriers that are still sort of remaining, moving on from the cases that Miriam, I think, very adequately discussed. And I saw in the questions that somebody said, well, with all these tort cases, do we still have an accountability gap? And I want to emphasize that, yes, we definitely still have an accountability gap. I mean, the Shell case, the Shell Nigeria case that Miriam just spoke about was actually the very first case where a foreign subsidiary company was actually found liable and ordered to pay compensation. And also the first case where a parent company was found to be under a duty of care on the merits. Still not ordered to pay compensation, by the way. It's just a duty of care to install specifically a leak detection system. That's the very first final decision by an appeals court on the merits that we have. So that's very slim. And also, it's good to keep in mind that this case, in a way, is also slightly flawed because the way the Dutch court uses English law, it's also a case based on English law. It's a common law jurisdiction where the damage occurred. Is still that very restrictive interpretation of duties of care based on Caparo and based on Chandler, which by the time the court should have known better, because this after the Fidenta decision, before the Okpabe decision, by the way, but they should have known better, and they still sort of misapply English law. I've got 2 articles on that coming out, but so there still is a lot that courts can learn from each other to actually understand where the law is heading. So that's one sort of critical point I have. The next thing is indeed, I think Miriam already said it, how to move beyond relations of ownership, because most corporate supply chains are not based on ownership. They're based on contractual relations. They're based on franchises. They're not just directly subsidiaries of a parent company. So the question that is with Begum, but also relevant for the Shell case, is what obligations do parent companies have to monitor behavior of contract partners? So in Begum, it's about shipbreaking, selling a ship to a Bangladeshi shipbreaker. And the question is does the UK-based shipping company have an obligation to ensure that ship is then broken down responsibly instead of in the terrible conditions where it actually happened? There's currently a case in the Netherlands that was brought. Oh, sorry, no, I have to get back to that later. So how to move beyond these ownership relations is, I think, is the next question here. Another question is access to information. One thing that the Okpabe case did was basically lower the burden on claimants to present their case at a very early stage. So the main question was, do these claimants sufficiently demonstrate a certain level of control of the parent company, and is their claim arguable? And the Supreme Court reduced that burden quite a bit, which is, I think, a big victory. But if you look to continental European cases, it's much more difficult to present those claims at this earlier stage. And also the procedures for acquiring such information, so disclosure, discovery, tend to be much more restrictive in continental European states like the Netherlands or Germany than they are in the United Kingdom. So even if you go past that initial point and get to sort of your discovery proceeding, it may be very difficult to demonstrate what the parent company did, what the relations were, how their interactions with their subsidiaries, suppliers, contract partners work. That's going to be a very significant difficulty. I do hope that the disclosure and identification of human rights risks aspect of these due diligence legislation will help in that respect, but thus far I'm quite skeptical. Then there's the question of applicable law, which Miriam also raised. I won't dwell on that too much. Two things I want to say about that. I want to say, keep in mind that the Shell case, the climate case that we just spoke about, is really a matter of Dutch domestic law. It is informed by the UNGPs and by the Paris Agreement and international standards, but at the end of the day, the whole construction is based around Dutch unwritten duty of care law. And any other case that might not be the applicable law, and even I think on appeal, in the Dutch case, it may be, I'm not sure, but it may be that the Court of Appeal actually determined that the relevant harms occurred elsewhere, and may say that Dutch law may not apply to all aspects of that case. So that's still a major hurdle. It can also be an opportunity. We've thus far seen mostly common law jurisdictions and cases coming from common law jurisdictions applying English precedent. So that's the whole duty of care of Dantak Babi discussion. But there's now a very interesting case also in the Netherlands against Norsk Hydro concerning pollution in Brazil. Now, my expertise in Brazilian law is limited to non-existent, but I've been quite reliably informed by Brazilian lawyers that Brazilian law actually gives some opportunities to hold parent companies liable for environmental damage. Now, if that's correct, then sort of importing local law into a foreign jurisdiction like the Netherlands will actually provide with much better possibilities for litigation that just using Dutch law would have. So exploring the possibilities of local law, the law of the place where damage occurred, can actually, I think, be a sort of unexplored avenue of this type of litigation. Last point I wanted to make, we've emphasized the British cases, the UK cases quite a bit, not just here, but I think in literature, business human rights literature thus far. But one of the major obstacles to these cases in the early litigation was forum non-convenience, the possibility of a court to stay a case in favor of a foreign court if they find the case is more at home there. Now, as long as the UK was part of the European Union, forum non-convenience was off the table for litigation against UK-based companies. But now the UK is out of the European Union and also has not joined the Lugano Convention. The European Commission is really arguing against that. Forum non-convenience is back on the table. And it remains to be seen how much of a barrier that will be for future litigation. Ekaterina Rostova wrote a very interesting article on that for the Business Human Rights Journal. I really encourage you to check that out. But that might be another sort of stopper for future UK litigation. So again, some opportunities, some barriers still to overcome, and I think still an existing accountability gap. Thank you.
Thank you, Lucas. Thank you very much. Thank you both for having touched many and diverse aspects, also some very technical of these cases and of these developments. We have some questions from the audience, so I will try to summarize them to you both. I think you both can reply. First of all, it's maybe useful to clarify what exactly, why the UK cases, Vedanta in particular, have changed the control, what they have changed in the notion of control. Because and why this is important for future cases. Then how these developments are or will be will influence the development of the European due diligence legislation and or international lawmaking initiatives such as, for example, the UN Treaty on Transnational Companies and Human Rights. Will they? That's probably the question. And then an interesting question about how what will be the relationship between due diligence legislation and international human rights principles, meaning will there be a risk that focus on due diligence will take away emphasis from a more general duty of care as it's being developed by, for example, the UK jurisprudence? What's your take on that, and do you see any difficulty coming from this? I don't know who wants to start. Maybe Miriam, you want to start?
Yes, okay, I think I will start with the latter questions on human rights due diligence. Well, for example, I mean, I don't think that human rights due diligence legislation will take away anything from this developing duties of care, because it's really, in the end, it's I would say it's dogmatically quite separate legal routes, no? So, and plus, I would also be careful to argue that the duties of care created under tort law are necessarily wider and further reaching than mandatory human rights due diligence legislation, because those duties of care only come into play if you have a harm. So this is really to have a retrospective remedy for harm already being occurred. I think what is in the UN guiding principles, and then what you also see, I think what you see at the process of the UN treaty, which really tries to put the idea of UN guided, the risk approach that the UN guiding principles take into international law. That means that companies actually have to prevent harm from occurring, right, in the first place. And then only if they see a risk, they need to mitigate it. And if the risk has realized, then they need to remediate. And then only if they fail to do all of that, then comes the liability and into play, ideally, in terms of civil liability, criminal or administrative. So yeah, no. So I think that's why, while the tort, I would more say that I hope that the tort law developments give impetus and sort of a bit more a push towards mandatory human rights due diligence, and actually also how we've tried to argue that against the business entities in Germany who've been like the law would have been much more ambitious if it was not to the very effective business lobbying. So the government wanted to have civil liability, for example. But so what we've always been saying is, well, government, maybe you are better off if you really properly regulate mandatory human rights due diligence and attach liabilities to it, to really give a clear frame to companies so that they know what to do, while this whole tort law developments are very fluid, and it depends on court decisions, it depends on the cases to be brought. So, that's quite uncalculable. So I would more see this as, I don't think that I think if we get the right narrative and convince policymakers and judges of this, I think those two are should be mutually reinforcing.
Thank you. Lucas.
Yeah, the relation between due diligence and duties of care is a very complicated one, and I don't think we can do it justice in the time that we have. Indeed, I think ideally they are mutually reinforcing. I very much agree with Miriam that the uncertainty that is inherent in sort of in these tort litigations is very unattractive for companies, and maybe the certainty of a very clear policy framework or legal framework like human rights due diligence is slightly more attractive, and it may sort of help work the debate a bit that way. It could also mean that, and that whether that's a good thing, I'll leave that open, but that doing proper due diligence can be a defense against liability. So, well, we did our due diligence, we identified all the risks, and we did as much as we could, but still with this contractor or with the supplier, something happened, but we did everything we were supposed to do. And that can be a new sort of debate that you can have. But it can also be help against perverse incentives. And that's when I'm going to go back to your other question on the notion of control and Vedanta. Because it used to be the case that duties of care were only assumed if a parent company basically takes over operations of a foreign subsidiary. And in Vedanta, the Supreme Court, and in Okwabi as well, basically said, no, that's too restrictive. You have to just look at what the parent company itself did, not just whether they acted through their subsidiary, whether the subsidiary relied on it for knowledge and oversight, and whether they actively intervened, but whether they were in a position to intervene, but also whether they held themselves out to have control over their subsidiaries. So if a company says to its shareholders or to the outside world or to regulators that, yes, we have great quality control, we know exactly what our subsidiaries are doing, and then fails to prevent harmful acts over which it said it had control, that can also lead to a duty of care. Now, if you link that to human rights due diligence, what proper human rights due diligence essentially does is oblige companies to take that kind of control. So they have to hold themselves out to monitoring agencies, to shareholders. We are doing our due diligence in our supply chain. We are identifying risks with subsidiaries, with suppliers. We are in a position to use our leverage with our suppliers, but also to use the control we have over subsidiaries to mitigate human rights risks. And that, hypothetically, because again, no cases yet, but may feed into establishing a duty of care if it is found later that harms still occurred. So that's another sort of aspect to interaction. So the broadening of when a duty of care can arise for a parent company, I'd say goes a long way towards being a bridge towards this new developing due diligence legislation. By the way, assuming that the UK will have such broad legislation, because currently there's nothing in the draft still, but one can hope.
Thank you, Lucas. Thank you very much. There is just one question that is coming. I just take the time to read it. It's about the recent case, the Nestlé ruling. I don't know if anyone has had the time to read it, but should we be concerned about the establishment of connection to the business and human right to the business on human rights abuses, or be looking at the legislation to address this issue? I guess the question is more, can we hope that the judicial cases can do something, or it's necessary to have legislation, in your opinion, to address this issue?
Can I respond to that, or do you want to, Miriam?
Yeah, go ahead, Lucas,
yeah.
and then also Miriam.
So I spent most of my very sweaty afternoon yesterday reading the decision and trying to make sense of it, because it's a very complicated decision. But there's a couple of things I can say about it. First of all, it's really a decision based on US law. It has no direct implication for what's happening in Europe at all. It says nothing about the state of international law. It says nothing about the UNGPs, nothing about due diligence, which is, I think, by the way, also a main problem of that decision. But it's really about interpreting US law and the territorial scope of US law. And I'm happy to debate that later, because I think it's a fascinating issue. But that's the first thing to keep in mind. The second thing is, if you follow the court's interpretation, and I'm skipping over some nuances, but essentially they are at the point where English courts were before the Vedanta decision. So if you follow the Supreme Court's reasoning, essentially what they're saying is that you have to show as a claimant in a very early stage that some specific decision-making relating to the foreign harms took place on US soil. So the parent company directly had control over the harmful acts. So general controls that they had ownership and general policies, it's not sufficient. You have to show that they directly influenced that foreign decision, which is very similar, not the same, but very similar to how UK courts were looking at these duty of care cases before Vedanta. Again, lots of differences, but if you want to sort of conceptualize it and say, where are we at? That's where the US Supreme Court is at right now. Now, the last thing is, I'll do this very shortly. Sorry, Madalena. Yes. Just in general, apart from Nestlé, just court cases are never enough. Just legislation is never enough. It's always a combination. The one can feed into the other, and the other can push the one back, and so on and so forth. I don't think we should ever put our eggs in one basket, which is also my main problem with ATS litigation, because that did put all the eggs in one very fragile alien tort basket for a long while. And in some respects, I'm actually sort of relieved that it was so curtailed, because now we can actually explore much more effective options than just ATS litigation.
Thanks, Lucas. And Miriam, if you have a short comment.
Yes, no, thank you, Lucas. I very much agree, especially with this, you can never should we rely on one tool or the other. And I'd also just wanted to say that, you know, just because one of those cases is lost, I think probably in terms of case selection, I think that what it also shows is it's good to be smart about which cases you take. And I think certain supply chain cases are much more difficult to argue in terms of control and responsibility than others. I think there's also this question: how far does human rights due diligence, you know, go beyond the supply chain? And I think that is still the debate, right? So I think we also always need to be aware that this is, you know, bringing cases or lobbying for better legislation. It's always a struggle, and we need to be quite smart in wondering how far do we get. And, you know, and I think that's also something we should, as a human rights organizations should and activists should keep in mind.
Thank you, Miriam, also for this reminder, which I think it's very important in a landscape where more cases are brought and more possibilities are opened. So thank you, Lucas and Miriam, for this very interesting discussion and with a lot of things to debate on. We'll now switch to the next panel, which will debate on criminal liability. Because we know, of course, that also that too many companies are involved as well in the commission of crimes abroad. And in certain cases, they are linked directly or indirectly to very serious international crimes. However, the ability of companies to violate international humanitarian law has thus far not resulted in their criminal liability before international courts, even though to a certain extent, national laws have increasingly recognized the principle of corporate criminal liability, and numerous international conventions and regional instruments have called upon states to legislate in this direction. So we have the opportunity now to dive more in depth into this question, thanks to our next two panelists, Maître Emmanuel Daoud, who is partner and founder of the French law firm Vigo Avocat, and who has worked on several criminal cases involving multinational companies, and Montse Ferrer, who is business and human rights researcher and advisor at Amnesty International, who has also great experience in this type of cases and will also tell us more about a great project that Amnesty is working on in this area. So we will start by Emmanuel, and I ask you both to please summarize for us what is your perspective in the key developments of the recent years in criminal liability cases against companies. Why, on the contrary of what we have seen in the two panels that just precede us, why we don't see a real breakthrough in this area, and what are the arguments that are gaining traction or that you think could be further developed, and do you think this is an avenue that is still worthy to pursue? Emmanuel will speak in French, so for those who don't understand French, you have to go and click to the English channel in the interpretation toolbox to be able to hear his presentation. Emmanuel, à toi la parole.
Merci Madalena pour l'invitation. Bonjour à toutes et à tous. Peut-être deux observations liminaires avant de démarrer ma présentation, puisqu'on nous demande d'être bref en 7 minutes. Au cours de cette présentation, j'aborderai deux points qui sont les problématiques pénales et quelles sont les questions auxquelles il faut répondre en matière pénale pour envisager d'engager la responsabilité pénale d'une société mère par rapport à l'action de sa filiale. Et peut-être, en tout cas pour le droit que je maîtrise, qui est le droit pénal français, dire qu'il y a des points positifs et être peut-être un peu plus optimiste que ne l'a été Madalena dans son propos introductif. Le propos liminaire que je voulais développer, c'est le suivant, et j'espère que vous n'allez pas clore votre enregistrement au moment où je vais tenir ce propos, c'est que je souffre totalement de schizophrénie, puisque à la fois je suis avocat et je suis aux côtés de la Fédération internationale des Ligues des droits de l'homme, mais je suis aussi avocat d'entreprises multinationales, et pour citer deux d'entre elles, sans violer le secret professionnel, parce qu'on le sait, comme Carrefour et L'Oréal, et d'autres entreprises de cette taille. Pourquoi je vous le dis? Parce que je ne voudrais pas oublier de souligner que ce soit en matière de responsabilité civile, ou de responsabilité pénale, ou de plaidoyer, je puis vous assurer que l'interpellation publique des entreprises par les ONG qui annonceraient des actions contentieuses ou précontentieuses, aujourd'hui, notamment pour les sociétés cotées, a un impact significatif. J'ai prêté serment en 1988, je traite de ce type de contentieux depuis plus d'une vingtaine d'années, et sur ces 5 et 10 dernières années, on va dire 5 dernières années, la possibilité pour les ONG d'avoir, ou les citoyens et citoyennes qui se regrouperaient derrière des actions collectives, d'avoir un impact immédiat sur la prise en considération des problématiques relevant du respect des droits humains est beaucoup plus significative aujourd'hui qu'hier, et ce sont des sujets qui sont débattus au niveau des directions générales. Je ne veux pas faire preuve d'un excès d'optimisme ou ou d'être, comment dire, dans une logique qui voudrait dire que tout est réglé, parce que sinon nous ne serions pas autour de cette conférence. Mais je tiens quand même à le dire, parce que je ne le vis pas au quotidien, mais je me rends compte, pour en parler avec d'autres confrères et consoeurs, en tout cas pour la France, qu'il y a là un sujet et un sujet d'avancée positive. Je vais dorénavant traiter le sujet ou le thème qui m'a été confié. Je vous disais en introduction quelles sont les problématiques de la responsabilité pénale des multinationales. La question à laquelle on doit répondre, est-ce que l'on peut engager la responsabilité pénale d'une société mère pour les agissements de sa filiale située à l'étranger? Premier élément qui est un obstacle et qui est un principe de droit pénal qui est partagé dans beaucoup de systèmes juridiques, on considère qu'une personne physique ou une personne morale, mais parlons des personnes morales, n'est responsable pénalement que des faits qu'elle a commis personnellement. Si l'on retient ce principe, on peut considérer que l'on ne pourrait jamais engager la responsabilité pénale d'une société mère pour les agissements de sa filiale. Autrement dit, l'autonomie de la filiale, la personnalité morale au sens juridique du terme de la filiale, dresse un mur étanche entre sa responsabilité pénale, par exemple pour des faits qui seraient commis au Cameroun pour la filiale camerounaise d'un groupe alimentaire, par rapport à la société mère qui se trouverait en France. Et tout le travail qui doit être fait par les avocats ou les avocats, tous les militants et les militantes, et aux côtés des victimes, c'est d'essayer de dire que ce principe n'est pas intangible, qu'il est relatif, pour essayer de faire tomber ce mur qui est constitué par l'autonomie des responsabilités pénales et des personnalités morales de chacune des deux entités. Est-ce qu'il y a la possibilité de le faire? La réponse pour moi, et en tout cas au regard de la jurisprudence française, est une réponse positive. Nous voyons ces dernières années de plus en plus des juridictions reconnaître l'engagement de la responsabilité pénale de la société mère concernant les faits commis pour sa filiale. Un exemple parmi d'autres, l'affaire pétrole contre nourriture qui concernait Total. La Cour de cassation, la chambre criminelle de la Cour de cassation, c'est-à-dire la plus haute juridiction en droit français de l'ordre judiciaire, a considéré que l'on pouvait retenir la responsabilité de Total société mère pour les agissements de sa filiale pour des faits de corruption d'agents publics étrangers en retenant plusieurs critères. Ces critères essentiellement, quels sont-ils? La filiale était détenue par la société mère à 100%, la filiale ne bénéficiait pas d'une autonomie financière et décisionnelle, les opérations comptables, et ça a permis dans ce dossier de remonter la traçabilité et d'assurer la traçabilité de ces opérations comptables litigieuses, remonter au siège de la société mère qui en avait nécessairement connaissance, et les juges ont considéré que la filiale n'était qu'un simple véhicule juridique, je mets cela entre guillemets, qui était utilisé par les dirigeants de la société mère pour la mise en œuvre des décisions financières, en l'occurrence dans ce pays, la mise en œuvre de décisions financières qui ont abouti à des agissements de corruption. Et donc, grosso modo, si l'on veut synthétiser le propos, l'on doit retenir que pour les juridictions pénales françaises, à défaut d'autonomie totale de la part de la filiale, on pourrait retenir la responsabilité pénale de la société mère. C'est exactement le même raisonnement qui a été suivi dans une autre affaire qui concerne Total, qui est l'affaire que l'on appelait l'affaire Erika. Vous savez, cette pollution environnementale. Total SA a été considéré comme responsable pénalement des faits commis par sa filiale panaméenne qui était la propriétaire du bateau qui l'avait affrété. Donc là encore, et c'est une décision de la chambre criminelle de la Cour de cassation qui a reconnu l'absence d'autonomie de cette filiale par rapport à la société mère. Donc, dans un premier cas, nous avions des faits relatifs à des agissements de corruption. Dans la seconde hypothèse que j'évoque à l'instant, c'était une pollution environnementale. On peut citer un autre exemple, et dans un dossier où nous avons travaillé avec la FIDH et pour le compte de la FIDH et avec Madalena notamment, nous avons déposé plainte entre les mains du doyen des juges d'instruction à Paris. L'affaire est publique, hein, cette plainte est connue, elle a donné lieu à une interpellation publique contre la BNP Paribas Société Mère et la BNP Paribas Suisse pour des complicités de crimes de génocide, crimes contre l'humanité, torture, pour avoir financé en connaissance de cause le régime soudanais d'El-Béchir à l'époque où ce régime soudanais avait été mis au banc de la communauté internationale et où le Conseil de sécurité avait saisi la Cour pénale internationale pour engager des poursuites pénales contre les dirigeants soudanais. Et nous sommes partis de l'accord qui avait été signé par la BNP avec le Department of Justice américain, accord transactionnel devant un juge pénal américain qui avait reconnu pour la BNP la matérialité des faits. Et à partir du moment où ces faits étaient reconnus, quels étaient-ils? Des comptes bidons, l'interposition de sociétés écrans, la parfaite connaissance par les dirigeants de l'époque, je parle des dirigeants de la BNP, des exactions, pour les appeler comme ça, du régime soudanais. Nous sommes partis du point de vue du constat suivant, cet accord n'avait concerné que le Trésor américain et le département de justice américain. Il n'était pas opposable aux tiers, et notamment aux victimes soudanaises. Et donc, nous avons saisi la justice pénale française et notre plainte n'a pas été déclarée irrecevable. Tout à fait récemment, il y a eu une plainte qui a saisi, là encore, le doyen des juges d'instruction français dans une affaire concernant le recours par des entreprises du textile à un approvisionnement en coton en provenance de Chine et dans une province où il y avait des camps d'internement et de travail forcé frappant la minorité ouïghour. Nous ne savons pas ce qu'il sera demain de cette action, mais tout ça pour vous dire qu'en France, en tout cas, le droit pénal est utilisé de façon proactive et avec des résultats. Et ce que je remarque, c'est que les juges pénaux français s'inspirent, notamment dans l'appréciation de l'absence d'autonomie et du lien de dépendance économique, organisationnelle, politique de la filiale par rapport à sa société mère, au droit de la concurrence tel qu'il est défini par la Cour de justice de l'Union européenne ou en matière de droit des sociétés. Par exemple, c'est une décision du 5 mars 2015 qui s'appelle Modelo Continente Hipermercados S.A. Contre Autoridade para las Condiciones de Trabajo. C'était une décision qui concernait le Portugal. Et le juge européen a considéré qu'une fusion par absorption entraînait la transmission à la société absorbante de l'obligation de payer une amende infligée après cette fusion. Donc, ça, c'était du droit des sociétés. Aujourd'hui, la Chambre criminelle de la Cour de cassation en France a considéré que la société mère était dorénavant responsable des agissements susceptibles de recevoir une qualification pénale dans le cadre d'une fusion-absorption, c'est-à-dire que la société absorbante avait dans son patrimoine, transmission universelle de patrimoine, tous les agissements de la société absorbée. C'est une décision qui a été rendue il y a 1 mois et demi, qui est tout à fait révolutionnaire en droit pénal français. Ça n'avait jamais été admis jusqu'alors. Ce n'est pas un arrêt isolé, c'est une décision de principe qui a été publiée par la Cour de cassation, qui a été abondamment commentée. Auparavant, on considérait que la société étant absorbée, elle était morte juridiquement et on ne pouvait plus la poursuivre pénalement. Aujourd'hui, le juge français pénal dit « société absorbante, vous êtes responsable ». Oui, Madalena?
Oui, Emmanuel, juste pour te dire que
c'est fini.
Le temps, c'est fini. Donc, si tu peux conclure.
Dernière chose, et en 5 secondes, puisque nous avons parlé dans la première étape du volet justice climatique, sachez qu'en France, puisqu'il y a beaucoup de sociétés comme EDF ou Total qui sont concernées, le Parlement français a adopté en première lecture des délits nouveaux, des délits donc des infractions pénales comme le délit d'écocide. Et compte tenu du principe de territorialité de la loi française, on pourra poursuivre dorénavant une société mère française pour des délits relatifs au droit pénal de l'environnement commis à l'étranger. Je me tais, j'ai été trop long.
Merci Emmanuel, merci beaucoup. Montse, so now up to you.
Hi, can you hear me?
Yes, we hear you very well.
Well, thanks again for inviting me, and I'll I will answer 3 of your questions, maybe just as a quick reminder to the audience what the questions are, but a couple of recent developments are really talking about the trends that we've seen in criminal liability, then why are we not seeing more breakthroughs, and finally, why, despite the fact that we're not seeing more breakthroughs, should we continue pursuing criminal liability? So I'll start with a quick sharing of screen. Madalena mentioned earlier that I am part of a project called the Corporate Crimes Project. I manage it at Amnesty International. We are going to be launching a website next Tuesday. I won't talk about that today, but what I did want to quickly share with all of you is what this, one of the tools, hope you can see it, one of the tools that this website is going to have, and it's a map, a case map. You can see here, you can go around, you can see the different cases. And basically what this case map is cases filed, criminal cases filed against corporate actors, both individuals and corporate entities, for corporate crime that is linked to human rights abuse. And in most cases, we're talking about some form of cross-border cases. Either the incident took place in one place and the case was filed elsewhere, or other. I'm stopping to share the screen now. So that's going to come out on Tuesday. But what I want to do now as a quick preview is what have we learned from this report that we're coming out, or more that this tool and this case map of criminal complaints filed around the world. So first is that civil society is taking a very active role, we'd say a more active role than prosecutorial authorities in terms of collecting evidence and commencing cases. I don't mean formally judicial authorities in some jurisdictions are the only ones who can commence cases in civil law country, in common law countries, but the idea of commencing more broadly, as in NGOs are investigating these cases, they're bringing together all this evidence, and they're either submitting it directly as a complaint, as Emmanuel just mentioned, FIDH and his law firm have done, or in other ways where you share the evidence. So civil society is very active. Where are we seeing most cases? Well, France, hence Emmanuel's presentation. France is one of the most active jurisdictions. Germany, we have ECCHR who's spoken at the previous panel. They're big litigators, FIDH, big litigators, but many of the cases are in Europe, and particularly France and Germany. Another thing that we're seeing is that these cases rely extremely on collaboration. So while you will find some, for example, European NGOs that are filing a lot of these cases, they rely on a collaboration with an NGO that is based in the region where the incidents took place. So that collaboration is essential. Without it, you don't have most of these cases. In terms of what are the trends, and this is very much in line with what Emmanuel was saying, the last 10 years are extremely different than the previous ones. So from the cases that are in the map, about 10% of them were filed between 2000 and 2009, and 90% afterwards. Also, we have around 35% of cases that were filed between 2018 and now. So really the more we advance in terms of time, the more filings we're seeing. 60% of the cases are ongoing at the moment. And in terms of what types of crime, Madalena mentioned some of this initially, but we're looking at international grave crimes such as genocide, crimes against humanity, torture, and war crimes. Those are about 50% of the cases, and the other 50 range from financial crime linked to human rights abuse, environmental crime, labor rights or labor right violations, etc. So that's what the case map shows. But the bad news, and this is where we're going to go to the second question, is, well, how many convictions are we seeing? And at the moment we have, this is just an indicative figure, but we're talking about 5% or less of conviction rate, which is very low. That is true of other areas of the law, not only corporate accountability, but 5% in corporate accountability is in some ways it's even optimistic. So why are we not seeing a breakthrough that we were hoping to see? First, let me say that we're fighting an incredibly powerful enemy. And I don't mean that all companies are enemies, not at all. I'm talking about those that commit human rights abuses. Those are, especially in the criminal context, are enemies that are powerful, they're well equipped. They have used legal and as well as physical force to threaten and to fight the NGOs who are fighting these cases, and especially the victims and communities that are affected. So in the space of criminal accountability, we're not talking about negligence. We're not talking about a company that without intent committed a wrong, quite the opposite. And intent, which I bring up right now, is one of the reasons why we're not seeing so many breakthroughs in terms of the fact that generally proving intent in criminal, in any case, but in criminal obviously, is very, very hard. That's one of the challenges, but I'd say the bigger challenge perhaps in the criminal space is that there is still a significant lack in political will. And what do I mean by that? So even if NGOs prepare very strong cases and they file them with prosecutors who are very interested in pursuing these cases, they may not have the political will institutionally in their departments of justice or in their government, or even civil society that may not have reached the point to say, yes, criminal liability is important against companies. So the lack of political will, I'd say, and especially when you think about cross-border cases where there will be, or they may be political ramifications, the lack of political will is one of the biggest challenges. In addition to that, hard to collect evidence, expertise is essential. A lot of these companies operate in quite complex financial and business areas, and having the expertise to understand, analyze the data and evidence that's collected and or presented is quite challenging. There are obviously jurisdictional issues Emmanuel mentioned, but of course in some countries you can't file a criminal case against a corporate actor, and by actor, sorry, a corporate entity, you can only file against individuals, and that makes it much harder. So the list rather of challenges is a very long list. So I guess I'll end with the third question, which is, well, why are we pursuing criminal liability? Is this worth our time? And I'd say absolutely. I'm also biased because that's my job. But, and I think a lot in this call also are biased, but I still have a claim to make here, and it's two things in particular. One is remedy. When we talk about remedy, we usually talk about civil compensation, and that's essential for a lot of communities. Also, other types of non-monetary compensation. But in the criminal context, we're talking about justice, and that is a form of remedy, and a very important one. Having worked a lot with victims and individuals who filed complaints, being able to know that the individuals who are responsible for the wrongdoing that have caused them harm are being put to justice in a very personal way is very important for them. And the second one, and I'll go back to one thing Emmanuel said at the beginning of his presentation, is deterrence. So I also, no longer, but I used to for almost 10 years worked for companies. I was in the private sector and I represented companies. And I will tell you, this is anecdotal, but I think it's quite reflective of the space we're in. The first question when I met with members of the board or with senior officers in companies, the first question they asked in the context of a potential corporate investigations against wrongdoing was, am I going to go to prison? Is there a risk that I will go to prison? And I can assure you that the moment the answer was yes, the stakes were very different and companies approached the issue very differently. Of course, social media now can create a storm for companies, but that's very different than an officer, a CEO, a CFO, a member of the board being able to be criminally prosecuted. And that changes the stakes of how a company defends itself, but especially how a company behaves moving forward. So I'll stop there. I'll shift it to Madalena. And yeah, thank you.
Thank you very much, Montse, and thanks, Emmanuel, both of you, for also the picture, but also the optimistic view on the possible developments, and to remind us why criminal liability is fundamental for justice, actually. There is one question, there are a couple of questions that are on the same topic, so I will ask them as one question. And I ask you to be very brief. You have 1 minute each to reply. But I think these questions are very timely and important and are about the relationship between corporate criminal liability and the due diligence legislation. So do you think that due diligence legislation should include provisions on criminal liability? And what could be the influence of due diligence legislation on criminal cases against companies, in your opinion? So we'll start maybe with Montse and then with Emmanuel. 1 minute.
1 minute, I'll do this fast. So I'm not an expert on due diligence. I'm much more on the criminal side, but I guess that answers a little bit of the question, which is most of the legislation is looking more at civil versus criminal liability in the space. And for, I think, in some cases, good reason. I would say, though, for legislation that focuses only on civil, that already is a big step forward, because part of the political will that I was talking about is that there still is a lot of reticence at the domestic judicial level to prosecute companies. And if you have already human rights due diligence laws, they will push the agenda forward. Of course, I do think that in some instances there should be criminal accountability in relation to human rights due diligence. But even if we don't have that, I think that's a step forward. And that's 50 seconds. So 10 seconds.
Thank you so much. And then I ask the same question to Emmanuel.
Alors, je pense qu'il y a une interaction évidente et dans la mesure où le juge pénal est saisi à la fois de l'action publique, c'est-à-dire la sanction pénale, peine d'emprisonnement et peine d'amende, mais aussi des dommages et intérêts sur le caractère civil et dans le cadre de la caractérisation de l'infraction de l'élément intentionnel. Et quand on dit élément intentionnel, ça veut dire est-ce que les dirigeants sont informés? Et on va regarder les codes de bonne pratique, les chartes informatiques, les codes de déontologie et les obligations de due diligence qui pourraient être résultées de lois spécifiques de nature civile. Donc, ça va être pris en considération, il y aura une interaction et il y aura un impact, et ça sera une très bonne chose pour les actions pénales à venir lorsqu'on est du côté des demandeurs naturellement.
Merci beaucoup, Emmanuel. Et il y a aussi une demande de si tu pourrais mettre dans le chat la référence de l'arrêt de la Cour de cassation.
Je n'entends plus Madalena pour ce qui me concerne.
Ah, yes, sorry, because I'm probably in the English channel. If you can put in the chat also the reference on the Cour de cassation, on the judgment that you mentioned of the Supreme Court.
Je vais essayer de le trouver, sinon je le transmettrai via Madalena.
Thank you very much. Thank you very much. So thanks a lot to Emmanuel, Montse, but also to all our panelists and all those who have contributed with questions and reflections to make this, in what my opinion, has been a very rich and lively discussion and debate. So it's now time for some conclusive remarks. And we are particularly honored to have here today to do so Professor Surya Deva and Professor Anita Ramasastry, who are respectively Vice Chair and member of the UN Working Group on Business and Human Rights. We have celebrated this week the 10th year anniversary from the adoption of the UNGPs. We have spoken also a lot of the UNGPs in the past during this discussion. And after all you have heard here today, and also on the basis of your extensive experience, both as UN Working Group members, but also as academic working on these issues for years, we would really welcome your reflections on what lessons can be drawn from the developments in the corporate accountability field, and what are, in your opinion, the next steps that can be taken at international level to meaningfully improve access to justice in cases of corporate abuses. And I will ask then first Surya and then Anita to give us their reflections on those topics. Thank you.
Thank you very much, Madalena. It was, thank you for the invitation. It was really a fascinating webinar, and I learned myself quite a lot from different panelists, so a very rich discussion. So I will make 2 points. One is about lessons. I will highlight 3 lessons, and I will highlight 3 suggestions as a way forward. These reflections, I would say, are my personal reflections, not of the working group. And these reflections are based on my experience in the last 20 years in this field of business and human rights. So I think they're much broader than the UN guiding principles focus. So I'm looking at the broader canvas. What have we achieved and what we have not achieved and where we should be going in future. But let me start with an opening remark. And my opening remark is that I think we should make a distinction between access to remedy and the effective remedy as an outcome. Because sometimes or often we confuse the two. We sometimes, in my view, over-celebrate cases like Vedanta and Pabi. But these cases do not always result in effective remedy. And of course, not every victim could file a case like Vedanta. So I think we have to be aware of what we're talking about here. There are thousands and millions of victims who are suffering, and not everyone is able to file a case like this. And what do you get out of it? Perhaps at best, a compensation, which is confidential, no public apology is offered by the company, and of course, there is no criminal liability in most of the cases. So this is not effective remedy. This is at best partial remedy. That is my opening remark, which I wanted to make. So I think we should make a distinction between the process and the outcomes. And unless the outcomes are effective, I think we should be cautious in celebrating that. In terms of the lessons, the first lesson I think we can learn is that UN guiding principles, of course, have made unprecedented impact in terms of political commitment and on paper implementation. But if the pillar 3, if we look at it, I think it has made, in my view, least impact in practice in terms of seeking remedies. And of course, there is this recent Shell case on climate change. But otherwise, if we look at the judicial remedies, the impact is very insignificant, I would say. And of course, Vedanta and Pabi, they are irrespective of UNGPs, right? But let us look at beyond those 10 years. And I will take here the Bhopal case as a touchstone to see what progress we have made in the last 36 years, right? So if you look at the Bhopal case, it presented the number of challenges, and I will highlight 3 here. How to hold the parent company accountable, the doctrine of forum non-convenience, and the burden of proof. There are many others, but let me focus only on these 3. Now, if you look at the last 36 years, what progress have we made? I think very little. Parent company liability, of course, there is this direct duty of care principle, but this is not a principle universally applicable in all jurisdictions all over the world. And there are significant other limitations, whether you can win the case on a merit, that is a separate question. Forum non-convenience, of course, if you look at European Union, the picture is very different because of the Brussels 1. But outside, and now even UK, forum non-convenience is likely to be back. And of course, if you look at other countries, including the US, the situation is, I don't think we have made much progress on FNC. So if the Bhopal case happens today, I think the outcome is going to be likely very same. Third is burden of proof. I think it is very difficult to establish a cause of action. Access to information is not there and all this. That was difficult in the Bhopal days, and it remains difficult. So I think that is my first lesson, that in terms of judicial remedies, the outcomes have not changed much. Second, the point that I would like to make is that in my view, UN guiding principles do not challenge the structural issues or imbalance of power. And I would like you to invite, as a concrete example of it, the Olivier de Schutter's piece, which he shared in a different context. But I think that piece highlights this point. Earlier this year, I wrote a piece about what is a just recovery and for whom, that alludes to this point. And I think we need to go this beyond. UNGPs will remain central, of course, but I think we need to look beyond UNGPs rather than thinking that business and human rights equals to UN guiding principles. So unless we address those imbalances of power and bring civil society actors, trade unions central to the whole issue of remedy, I think we will continue to face those difficulties. My third lesson and the last lesson I would like to highlight is the hard cases. I think seeking remedies is extremely difficult in what I will call hard cases. What is meant by hard cases? Now, when we talk about Vedanta cases, shell types of cases, you can at least file a case in the home country of a company. But what about a situation in which the home state is a state where you can't file a case? I will not name the country, but there are many countries now which are part of the global south, and those are the home countries, and you cannot file a case in the home country at all. There's no chance of filing a human rights violation case there. And of course, the host country is again having a governance gap. So how do you seek remedies in those particular situations, right? Or if you have a company which totally disregards UN guiding principles or other soft standards, how do you seek remedy in those particular situations? They don't care. So these are the hard cases when the states do not offer viable option and the companies in question is also not doing it. What is the way forward? Of course, I will not offer the typical responses, oh, let us have a treaty and implement the accountability and remedy project recommendations. Yes, we need all of that. But I'm going to say something unconventional, if I could. And I would say 3 points here. First is the corporate capture of the state. Unless we deal with this elephant in the room, we will struggle to hold companies accountable. Corporate capture of the state is very real. And I think guiding principles cannot dismantle this capture in my view. So we need to make companies more democratic institutions. We need to fundamentally change the landscape. Do we need such big companies, for instance? These are the questions we should be asking. Should we go back to small and local companies? Will they be more sustainable? Rather than exporting fruits and vegetables 8 and 20,000 miles, you know? So is that model sustainable? And of course, it raises a question of complex supply chains and all that. My second point is that we need to look at accountability in a non-state, non-corporate mechanism setting. And here I would like to look at the use of social media. But I would like to say that people's tribunals could also be very powerful in storytelling. I think someone was talking about earlier about storytelling and building a narrative or countering a narrative, which is done by the media, which could be controlled by corporations, right? So I think that is there. My last point is that we should resist weak mandatory human rights due diligence legislation or remedy less human rights due diligence legislation. There could be a temptation that, okay, this is mandatory and let us celebrate it. Let us go for it, right? I see several red flags in these emerging mandatory human rights due diligence legislation. And I agree that the relationship between the tort liability and these legislation is complex, but I think they could backfire for victims if we do not design them properly. So I think that is my last point for now. Thank you very much once again for the invitation.
Thank you very much, Surya, for these remarks and for reminding us the difference between process and outcome, and also for pointing out that there is a difference between patches and addressing the problem, which is also the business model and the model where we live in. So I will now switch to Anita for her conclusive remarks and her reflections on the lesson learned and the way forward.
Great, thank you so much. And I want to thank FIDH again for the invitation to join this inspiring panel today. I congratulate you on the publication of this important new resource for civil society that is focused on access to remedy. And like Surya and like many others here today, I've been working in the field of corporate accountability for more than 20 years. And I've seen in the past decade, in some way, surprising movement in business and human rights with concepts like mandatory human rights due diligence, even moving to regulation and addressing forced labor and supply chains. But on most days, it still feels like an uphill battle. So maybe the slope is just not as steep anymore. And my own work has focused on corporate crimes and prosecutions. So I was pleased to hear from Mansi today and agree with many of her remarks. But let me complement my colleague Surya's remarks by adding a few reflections as we end the week in which we commemorated the 10th anniversary of the UN Guiding Principles in Business and Human Rights. And I'll speak a bit more about the working group's work. After a decade of UN guiding principles implementation, the working group released a report to the Human Rights Council this week, which is a stock-taking report. It's looking back at what has happened after 10 years of the guiding principles. And what did we conclude? First, that the UNGPs in some ways are a game changer, but that the game is really not over. And I think I agree with Surya's points that the game is somehow in some way rigged, and that unless we address the underlying issues, the game will never be over. But the UNGPs foresaw many of the key issues that do need to be improved to realize robust progress on business and human rights. And these gaps still persist. So our report really does say, look, the gaps that were there remain. So we still see that there are ineffective measures by states and business to prevent adverse human rights impacts, including not enough meaningful engagement with workers, communities, and others affected by business activity. We suggest that over time, improvements in consultation do lead to better prevention and trust among stakeholders, but this has not occurred. And we note that there are significant barriers to access to remedy for victims of business-related human rights abuses, such as well-known legal, practical, procedural, and jurisdictional hurdle. As Surya mentioned, and I think we heard from Lucas and others, there's so much guidance. The working group, through Surya's leadership, has an important report focusing on what is effective remedy for business and human rights violations. There are multiple studies from the European Fundamental Rights Agency, the Council of Europe, the Office of the High Commissioner for Human Rights on Accountability and Remedy. The challenges are no secret, quite the opposite. So we also noted that it was time for mandatory measures, as voluntary alone had failed. And what we're doing now is urgently needed in terms of moving from voluntary standards to mandatory ones. So the recipe of the smart mix in the UN guiding principles has changed, and it needs to change with more mandatory and less voluntary. And this is because of the urgency around remedy and rights holders. The harm continues. So the present landscape presents opportunities. We need to reinforce the current wave of mandatory due diligence laws and make them effective. But as Surya points out, this is really a challenge, and we're not seeing this as a solution yet, because these laws are not part of a larger holistic framework that takes into account all three pillars. Due diligence is a tool for prevention, but if harms occur, then remedy must be provided, and that brings us into pillar 3. So right now, we have laws that are focused really on process and pillar 2 only. Remedy should not require years of transnational civil litigation. And so this also means rethinking the role of the professions, including defense lawyers who ethically advise their corporate clients. Business and human rights should not be about winners and losers in the remedy concept, and the concept of what we call zealous or resolute defense. Many transnational tort cases spend years just on procedural issues before getting to the merits. But if now the models of mandatory human rights due diligence focus really on pillar 2 and don't link to access to remedy. France is an exception. So Miriam spoke of the German supply chain law, which does not provide for a new cause of action in civil law for companies liable for damage because of their failure to comply with due diligence obligations. And the new Norwegian Transparency Act passed last week also does not provide provisions for civil liability. Now, Surya mentions it's complicated, and I agree. So it's not just allowing for civil liability, we have to get it right, but the absence is a gap. So without the linkage, there's a serious gap, and the EU directive remains an open question. Now, the working group has consistently called for key provisions relating to accountability and remedy in due diligence laws. Our October 2020 letter to the European Commission states this. And I'll just mention in conclusion, a few steps that the working group is taking to try and make remedy a reality. Now, our work, we are just a small group of independent experts. So our work is meant to backstop and reinforce the important work of civil society and lawyers and others. We can only state what the expectations are for states and business and try and use the power of UN special procedures to engage in this debate. But really, it is all of you here today that are the ones that are the leaders. So the working group is engaging with national human rights institutions to strengthen their ability and leadership in this space. And a report will be presented to the council this June. And this work is ably led by Surya. Second, we will continue to push for liability and accountability in situations of business and conflict. And we'll be issuing guidance and a framework for how companies should participate in transitional justice mechanisms and how states should address the role of business as participants in conflict and in the commission of crimes. Third, this month, we are issuing new guidance on the UN guiding principles and the rights of human rights defenders. And here we will focus very much on the use of SLAPP lawsuits to silence defenders. And fourth, we will continue to examine the way in which we can use other areas of the law, such as corruption, as an angle to pursue corporations that commit crimes that also lead to human rights abuses. So this is just to say that remedy remains on our agenda because, as we've all illustrated, we have made little progress in decades. So thank you so much.
Thank you very much, Anita, also for this powerful words and to remind us of the initiative that the working group is taking, but also of the limitation of the working group and the fact that we have to act collectively, otherwise those gaps will not be filled. So thank you very much, both Surya and Anita. And I thank again all the panelists and who accepted to be here today. Please, if you can, in the audience, fill this poll that you see now. It will help us quite a lot to understand what if this event has been useful for you. We are now at the very end of our journey today in the different aspects of corporate accountability. We heard about some promising developments, but also we heard that much remains to do to achieve true justice and effective outcomes, as Surya has pointed out, and true redress for corporate-related human rights abuses. We can only hope that the next decade will bring some more of these effective outcomes, and that civil society, lawyers, academics, local communities, rights holders will continue to work together to achieve the justice that we deserve. With the guide that we launched today, we hope to contribute to that. Everyone can contribute to the guide by putting on, by sending to us developments that we can then collect, and you can also help by sharing it widely. I also wish to thank, of course, the globalization team at FIDH, Sasha Feyer-Rabend, Amy, Maria Isabel Cubides, and Ana Perez for their invaluable contribution and for made this possible. So if you want, you can contact us to the address mondialization@fidh.org. And I wish you all a very nice day and weekend ahead. And thanks again for this opportunity. Goodbye to everyone.